The U.S. Supreme Court is considering several important cases that will shape the legal legacy of Chief Justice John Roberts. In 2006, then-President George Bush signed the renewal of the landmark 1965 Voting Rights Act. The law outlawed discriminatory voting practices that disenfranchised minorities. It also set up federal oversight in some locations, mostly in southern states. Analysts say the issues could sharply divide the court. Ilya Shapiro is a senior fellow of constitutional studies at the Cato Institute in Washington.
On a lot of the controversial issues over the last number of years, it has been 5-4 going one way or the other, with Justice Kennedy holding the swing.
The High Court has already decided one case by that margin. Justices ruled that the federal law does not provide protections for voting districts where minorities make up less than 1/2 of the population. The decision is widely seen as narrowing the reach of the act. Court watchers are waiting to see how relatively new Chief Justice John Roberts will rule. John Britton is general counsel for the Lawyers Committee for Civil Rights under law.
Is Justice Roberts going to join in striking down the most significant reaffirmation of civil rights statutes in this 21st century so far as one of his major decisions and as a part of his legacy?
Legal experts say a challenge out of Travis County, Texas, could sharply divide the court. The Voting Rights Act requires federal approval of any changes in election procedures in places with a history of discrimination. Officials in a small voting district in the county wanted to move the location of some polling stations but did not want to get federal permission. Shapiro argues locations which have no specific history of racial bias should now be able to avoid federal oversight.
It might be controversial because it goes to the larger issue of whether these states, 50 years after Jim Crow, should still be governed by the federal government, unlike other states.
But Britton contends if the court sides with the Texas district, it would be a major setback for minority voters.
It would put the burden on minorities and on civil rights organizations to have to go to court, raise the money, take the prolonged time to appeal, and to ultimately, if they're successful, win.
Another case involves firefighters in New Haven, Connecticut. Out of 118 applications, no blacks and only 2 Hispanic firefighters passed an exam to get a promotion. City officials rejected the results, fearing the test was flawed since the white firefighters had disproportionately higher scores than blacks. But 18 white firefighters sued for reverse discrimination. They claimed the decision to cancel the test and promotions was race-based and violated fair employment laws. Britton sees irony in this argument.
Minority firefighters, African Americans and Hispanic, have been successful in many cases in challenging these tests as biased and discriminatory.
Analysts on both sides of the ideological divide are eagerly awaiting the decisions that could show how the conservative majority on the Roberts Court will define the future of civil rights law in America. Chris Simpkins, VOA News, Washington.